Thank you so much for watching Law School Made Easy. At Law School Made Easy 256, we thank you for subscribing, sharing, and liking our videos. Please, those of you who want to become members, press the join button below this video, and then you will subscribe and you become a member of this channel, meaning that if you become a member, when we send the videos, you get your video first before any other person gets. It is charged just 10,000 or 5,000, depends on what you really want. But we thank you so much. And also the other one, kindly try to watch the adverts. They're just 30 seconds. Please watch them and then let them complete. Is the only way you can support us, because this channel literally got monetized. So please watch the adverts as they play on these videos. So today we want to straight enter into the doctrines of separation of powers. We are in constitutional law, but we want to focus on the doctrine of separation of powers. This doctrine was discussed by Montesquieu, a French philosopher, in his book that he wrote, Spirits of the Law. Remember, in France, the Montesquieu, the Jean Rousseau, and others were some of the scholars who wrote against the revolution, that wanted the revolution to end. But Montesquieu, being a student of law and also having grown up in England, tried to discuss the principle of separation of power in terms of creating stability. In fact, before I go to Montesquieu's principle, I want to quote John Roju, who said that, John Locke, who said that where we have a solid separation of powers, then we are bound to have a good constitution. Where we have clearly demarcated the separation of powers, the government being clearly organized, then we are likely to have a very organized constitution. So this now takes me back to Montesquieu. He says that there are three arms of government, which is the judiciary, executive, and legislature. Montesquieu's teaching is very clear that these arms of government must operate independently, that the judiciary must operate independently, the executive operates independently, and the legislature operates independently. That is his teaching. Montesquieu goes ahead and says, for us to have a clear understanding of separation of powers, there is no single body who would appear in any of the arms of government. If you are the leader in the executive, Montesquieu does not expect you to be in the legislature or in the judiciary, because that would be interests, fighting for interests. Okay, for example, to explain clearly the principles of separation of power, let's use the 1962 Constitution, which provided that the president of Uganda would be Kabaka Mutesa, who was at the same time the Kabaka of Buganda and is the same as the president of Uganda. What does it mean? When Obote wanted to carry out the referendum, you see that Mutesa now was found at crossroads. He didn't know what to decide. Obote is operating under the law. Mutesa is the president of Uganda, but he's also the president, the Kabaka of Buganda. So you find that there will be conflicts in loyalty. So that is the exact teaching of Montesquieu, that when you are operating in the legislature, he does not expect you to be in the judiciary or the executive. So another ground principle for Montesquieu was that there must be each arm of government should be independent of the other. That each one of them should be independent, stand alone. Do your work as the legislature. Do your work as the executive. Do your work as the judiciary. And then he again said, there is no any other body that should be seen crossing, interfering in the affairs of the other body. That the legislature is not allowed to interfere in the operations of the executive. So that is the underlying principle of Montesquieu. So if you look at Uganda today, we have Article 77 of the Constitution. But before I go there, when discussing the principles of separation of power, dear students, the first thing we do is to discuss each arm of government, which article creates it and what is its duty. After the way I'm going to discuss them here, then we shall cross to what we call the checks and balances. Now, Article 77 of the Constitution creates the legislature, that there shall be a legislative body, a body that shall make laws. And in 79(1), it gives Parliament mandate to make the laws of the Republic of Uganda. This body shall be headed by the Speaker, who shall be voted from amongst the member of Parliament. So the head of the legislature is the Speaker, deputized by the Deputy Speaker and members of Parliament. They are the only people in charge of the legislature. Then Article 98 creates the executive, the office of the president, and gives mandate to the president under Article 99 and others to do his role, appoint ministers, disappoint. You can look at the case of Shabano Poloti versus Attorney General, where they had been dismissed from the army and they went to court. Courts told him it is the duty of the president to appoint and disappoint anytime. That would be our case. So it gives the mandate. The leader is the president and the cabinet ministers under Article 1011, 108, 108A, and 111, which creates the cabinet minister. The president shall be the head of the executive, with the vice president under Article 108, and the prime minister under Article 108A, and then all the other cabinet ministers under Article 111. So that is, its role would be to overlook the affairs of the country, to run the day-to-day affairs of the country, to think for this country under the stewardship of the president. And then we look at Article 126, which says the power of the judiciary of the courts is derived from the people, and the underlying principles the judges must follow while carrying out their duties. And then Article 129, which clearly talks about the courts of judicature. Which ones shall be the courts of judicature? And then we cross to 128, the independence of the judiciary. That for the judiciary to be independent and to work under Article 128, there are things which must be put into place to allow them space to operate when they are independent. So we are looking at Article 126, 128, and 129 of the Constitution, which creates the judiciary. Now, the judiciary shall be headed by the Chief Justice, deputized by the Deputy Chief Justice. We shall have the principal judge at the High Court, and then the Chief Magistrate, the registrars, and others, moving downwards. So that is what Montesquieu meant, that each one of those, the way I've talked about them, should be kept independently. But I want to borrow the words of Justice Emeritus Benjamin Odochi, as he was then. When he was Chief Justice, he said that the government, the three arms of government, they are like a cooking stone. Meaning that they are like a cooking stone, the three cooking stones. a pot seated on the three cooking stone. That when that pot is boiling, if you remove one stone on which it is seated, then the pot is bound to pour. So, meaning that they need each other. Each one of them should be independent, but working interdependently. That each one of them needs the other. And now that one takes us to what we call the checks and balances. That to ascertain this, that these three arms of government need each other. And the needing each other means that they are independent, but they work interdependently. So the checks and balances have been over time developed. That how do we check and balances? How do you ensure that these are independent, but they are working together? Because we have said from Chief Justice Emeritus Benjamin Odochi that the government, the arms of, is like the three cooking stones, a pot on the three cooking stone, that in removal of one, the other one will lack support, they would fail. So we now drive into the checks and balances. How have these arms of government been checked and balanced? How have they been checked? How do they check them? Let's begin with Article 100 of the Constitution. Article 100 of the Constitution suggests that the President, while leaving the country, shall notify the Speaker and the Chief Justice. Why is the President notifying the Speaker and the Chief Justice? Simply because they are checking on the powers of the President. They are checking them that as you go, let these ones know that you're not around. We work together. We are the three cooking stones. We work together. Let us know. If we proceed to Article 101 of the Constitution, presidential address, that the President shall occasionally address the nation through the Parliament, shall collaborate with the Speaker and addresses the nation. In clause 2, they say, from time to time, the President will continue to engage with the Speaker to decide on when to come and address the nation. All these, they are checking both Parliament and the executive on their powers. So that the President can sit in State House or wherever and begins to address. But you see, when it is a national address, you must come to Parliament and you address. The respect alone, coming to Parliament, is enough respect that the President is respecting the legislature and is following the rules or the law, how they are stipulated. Let's go to Article 104. In terms of presidential elections, presidential election petitions, that the court, the Supreme Court, shall act as a court of first instance while determining matters of presidential elections. You see now, elections have been carried out. One of the parties is contesting the results. You go to the Supreme Court, which is the judiciary, to determine. So now, the powers are given to the judiciary to determine. They are still checking the President and the judiciary. So that is how we go about most of these articles. We can continue Article 91 of the Constitution, Clause 5. Article 91, Clause 5, which says that where the President fails to assent to the bill 2 times, when it is brought to Parliament, the Speaker shall constitute a sitting and 2/3 of the majority, and they vote on passing that bill into law without going back to the President. All these are checks and balances. They are checking. So meaning that the President, you should operate very fast. If we give you something, operate, conclude it, and then we make it law. If you delay, Parliament has the powers to assent to it, and it becomes the law. Efficiency of work is now becoming more efficient. Let's look at Article 107, the removal of the President. In an event that we want to remove the President, under Article 107, we go through Parliament. We satisfy Parliament the reasons why we want to remove the president. If he has become insane, if he has become mad, and if he has failed to perform his duties diligently, if he has violated the constitution, we are free to go to Parliament and we organize for the censure motion for the president. You see now, they are checking the powers of the president, that Parliament can remove you from power if you misuse your power. That is under Article 107. Let's go to Article 108. That the president shall have the powers to appoint the vice president, but on approval of Parliament. That after appointment, they will send the names to Parliament to approve. You see, they are not leaving the president to operate alone. You appoint, Parliament shall do what? Shall receive, and then we make that person a minister. That is Article 108. And if you continue to Article 108A, the Prime Minister still shall be appointed by the President, but on approval of Parliament. They are checking. Now we can take us to Article 119. That is the Attorney General. Once he's appointed, the approval is done by Parliament. Let's go to Article 124 of the Constitution, which says that in the case of state of war, if there is declaration that Uganda is at war with Kenya, Uganda is at war with the Southern Sudan, or Uganda at war with the Zimbabwe, Somalia, or any other country, the president will seek the approval of Parliament. It's being checked. Will seek the approval of Parliament. You remember the other day when the first son, now the army commander, said that Uganda would attack Nairobi, and with no minute Nairobi is captured. Parliament was all over the space. Everybody, as who? You can't declare anyway. Why do you talk about it? It is the mandate of the president, but with consultation, with approval of Parliament, to declare that Uganda is at war with any other state. That is under Article 124. Let's go to Article 122. President would appoint ambassadors, but on approval of Parliament, to represent Uganda in other countries. Then we can look at Article 113, Article 113, which talks about cabinet ministers. That Article 113, that all cabinet ministers shall be appointed by the president, but subject to approval by the Parliament. Checks and balances. We can now think of Article 142, that president shall appoint the Chief Justice and other judges anyway, but acting on the advice of the Judicial Service Commission. That the president shall appoint those judges, but acting on the advice of the Judicial Service Commission, and later approved by Parliament. Look at the case of Karuhanga versus Attorney General, where the appointment of the then Justice of the Supreme Court, the Chief Justice Benjamin Odoche, was overturned because he had clocked the years, the age limit, where he would no longer serve as Chief Justice of the country of Uganda, and then it was overturned. By so, the judiciary had checked on the powers of the president. So that is what we call the separation of powers, discussed in constitutional law and administrative law. We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Thank you.